Hey, Michael, are you there?
Zach Galifianakis. If you haven't seen Between Two Ferns, it's a little talk show that Zach Galifianakis does, and you can Google it and it's on YouTube. But he sits between two ferns and interviews people. But Damian's head is always floating between two ferns here for me. So
That's awesome. Before you get started, I just want to mention too, if you have questions along the way, send them through the Q&A at the bottom of your screen, and we'll get them out to the guys. So with that,
cool.
Go for it.
Okay, well, hi guys. Appreciate Sarah the invite, and I know Damian and I both love doing stuff for SAR, and you guys are all fantastic. You've got a great association, and so thanks for giving us a little bit of your Friday afternoon. I wanted to, I guess I'll start, and then I think it's helpful to trace the history of the current stay-at-home order, and kind of where we've been over the last several weeks. It's been, as most of you know who have been paying attention, it's been pretty tumultuous in terms of, direction, misdirection, confusion, ambiguity. And I do, as Sarah alluded to, I think it's gotten more clear over the last few days in general, and not such necessarily great news, but at least clarity provides something for people, if nothing else. So this started back on March 25th. Governor Polis, it actually started about a week before that. Governor Polis issued kind of a limited version, and some of you will remember, he basically said, offices should have less than 50% of staff, and kind of we'll call it a stay-at-home light. And then over the course of about a week, it became pretty obvious that the virus was continuing to develop both, nationally and within Colorado, and that a lot of people were out. I saw videos of people parking around up Loveland Pass and hiking up Loveland ski area. And I know Berthoud Pass was, just jammed with cars going for miles in either direction of people outdoors and recreating. And Wash Park, and it was just a lot of people out and sort of disregarding it. So on the 25th, he issued what is the sort of current basis for the executive order, and that essentially did not have any reference to real estate at all in it. And so we had seen that coming over the prior week at CAR. We'd seen that sort of going in that direction. And so we were actively, our government affairs and lobbyists were actively working with the governor's office to try and make sure that when an executive order, a more restrictive order did come, then real estate was included. And so within literally 24 hours of the original order, real estate, among a variety of other things, was amended in as a critical business. And so that's where it was for about 2 weeks until I guess about a week and a half ago now. And then there was a broker here in the metro area, a listing broker, who essentially requested, I guess pretty adamantly, that a tenant vacate an investment listing that this listing broker had for the day, so that he could show it to a variety of investors during the course of the day. And to sort of add the cherry on top, the tenant was experiencing flu-like symptoms and pretty agitated about having to leave. But he did. But he also inquired or complained to the Attorney General's office about being essentially removed from his home for the day. And so that instigated the AG to look at it and sent a cease and desist letter to this individual broker and said, you can't do that. Under the order, showings are not permitted. And so when we got at CAR sort of a copy of that letter and the interpretation from the deputy AG that showings weren't permitted, it was a little bit surprising to us. And so we, myself on behalf of CAR, responded to the deputy AG basically saying, really a real estate transaction, at least in the Division of Real Estate's oversight, and as we would think of a real estate transaction commonly, begins at a brokerage relationship. So as clients signing an exclusive right agreement or being provided with a broker disclosure to a buyer, maybe as the broker's acting as a transaction broker, and it extends out over the course of the transaction through closing or possession of the premises. And that is what a transaction is and how it should be interpreted in the executive order. And they didn't particularly agree. In fact, they didn't agree. And their view of a transaction is that it is something that starts essentially at the execution of a buy-sell agreement between a buyer and a seller, or maybe a lease agreement between a landlord and tenant, and it carries on through the closing or possession of the premises. And so that was on Monday, not this last Monday, but the Monday before, when we got that guidance back, which was pretty upsetting and frustrating, because obviously all of the pre-contract stuff they consider to be marketing, but it's a pretty fundamental part, as you guys I'm sure would agree, being able to have showings and listing appointments, being able to install signs and do those marketing activities are really a pretty integral part of bringing a new listing to market for obvious reasons. And so then the next day there was a commission meeting, the regularly scheduled commission meeting. Damian and I were both, virtually in attendance at that. And there was a number of members of the public that showed up and started asking questions of the same deputy AG. And at that point it got to be like, are inspections allowed? And she said, no. Are final walkthroughs allowed? She said, no. Could we show vacant land? No. And so it got very, very restrictive over the course of that sort of formal commission meeting. And that really put up some crazy signals to myself. And Damian and I were sort of talking throughout the day. And so CAR at that point, our government affairs folks kind of got active and in front of trying to get the governor's office to appreciate that, listen, if a broker can only show up at a closing, that's literally the only thing that a broker can do under a real estate transaction, then you've essentially shut down the industry in many regards. And so over the course of about 24 hours there, we got some more clear and additional guidance related to the fact that a real estate transaction is at the commencement, at the contract execution, and it does go through closing. And so that would include activities like, inspection, walkthroughs of the property, and obviously attending closing. So the normal in-person brokerage stuff. And so that was, by that point in the discussion, it sort of felt like just a win to be able to get back to that point, because we've gotten pretty well, scalped with regard to what anybody could be doing. And so that was as of a week ago. And then during the course of last week, you guys are, I will say, and I know Damian and I have talked about this as well, realtors are a very creative bunch. And so your ability to come up with, scenarios, well, is this covered? Is that covered? Is this covered? It's pretty amazing. And so, I think that's one of the reasons that both of us were looking to get on here and maybe answer some of those questions. I think we're going to be seeing some additional guidance potentially directly from the AG's office about what can and can't take place. But I do think that we have a pretty good sense of exactly what that includes. And I think it really is confined to those activities, that take place after there's an actual contract being purchased. And so, maybe Damian, I'll let you, now that I've brought everybody up to speed on where we sit as of today. I know one of the things that, people say, well, geez, what do we do if we need to physically get a buyer to the property? And there's a scenario that potentially, going under contract with some contingencies. Maybe you want to chat about that a little bit?
Yeah, sure. I mean, first of all, none of this is ideal. I mean, frankly, though, I think what we have to remember is that in the environment that we're living in, there are a lot of industries that have just been completely shut down. And I know that the comments I get back is, well, yeah, but liquor stores and weed shops are still available to operate. And while that's true, could you imagine staying at home if you couldn't drink? I don't know, maybe that's just me, but my wife would say it would be very bad if she had to stay home with me and not be able to drink. So I keep in mind that I know that some of them don't make sense, and I don't know why they picked the ones that they picked that were critical and why they picked others that were not. I'm sure that the dentists would really feel like they're critical, but they're not. But we got to remember that the whole intent and purpose of the Attorney General's interpretation right now is to create less contact amongst people. And one of the things that the Division of Real Estate said is that there was this bad actor that Scott alluded to that the AG sent out a letter, but there were other complaints that were coming in too. A lot of the public was seeing brokers showing up to properties over and over and over again, being showings one after another and inquiring as to, how can they be doing this, and why isn't this a violation of stay-at-home order? And so because of that, that's really where I think that they started ratcheting this down. And while I may not agree with it, at least I understand the rationale behind it is to reduce the contact between people, so that buyers are not touching the same doorknobs, the same light fixtures, the same holes on the cabinets, the same toilets, the same everything else, and transmitting the disease. The solution that Scott and I have discussed, and he calls it something different than me, but mine's better, is that, we can still conduct business. We still have buyers, we still have sellers that have to work within this industry. And if a contract is being defined as contract to closing, or a transaction is being defined as contract to closing, then what brokers need to do is be more diligent with their buyers on the front end. Start having those conversations, going through virtually, looking through homes, getting it down to one property. Get it down to one property. They say, yes, I think this one is it. And we all know that without actually touching and feeling the property, they're not going to be positive. So putting in a contingency that is I call it a viewing inspection. Scott, you have a different name for it, I think.
But post-contract walkthrough contingency.
Post-contract walkthrough contingency. See, I told you mine was better. So
we can have a vote. You can poll on Zoom.
Oh, good. Let's Zoom. Let's poll. I want mine to be a viewing inspection contingency. But anyways, either way, it's the same concept. What it is let's get the buyer in there within 24 hours of going under contract. Let's let the buyer go look at the property. Let's let him touch it, feel it, sense it, find out if it's what he wants. And if it's not, let him terminate. And if he terminates, the contract's over, move on to the next one. Oh, yeah, sure. You get all the people that vote your way just because, it's got Peterson with car. So, but anyways, that's really the intent behind it, is to give you guys a mechanism. But it also meets the intent of the order in the fact that it is reducing the number of people that are going through properties at a time. It is reducing that contact and making it so that while we're still allowing real estate to move forward, while it's not as efficient, it still at least is meeting the intent of the law, is the way I see it. So you got anything to add besides how your stupid contingency is better than mine?
No, I think the only thing I would point out, it's just exact same concept, and it doesn't really matter what you call it, to be honest. I think it's that you make sure that if you're going to be using it, that it's something that addresses what your buyer's concerns would be. And I would encourage that that the walkthrough, or whatever you want to call it, occurs prior to the delivery of earnest money. And that way, in case you had some sort of bad acting or, bad faith kind of seller, your buyer wouldn't end up in an earnest money dispute, or at least if somehow they were, it wouldn't be some third party holding it there. So I think, a 24, 48-hour period to do this, post-contract walkthrough, and then if the buyer likes it, then deliver earnest money. If they don't like it, deliver termination and move along. And the only last thing I'd say on that is that, same concept. We're getting a lot of questions about, landlords who have vacant properties and doing leases. I think a landlord could add to a lease that is executed prior to a tenant seeing a vacant listing, a clause that would allow the tenant to, walk through the property and then terminate the contract if or the lease agreement if they didn't want to move forward. So they actually did put up a poll here.
Yeah, I see that.
Damian, you can't vote for yourself.
I can't vote for myself.
It says hosts and panelists can't vote, so not that I was trying.
Hey, can I address one other thing on this contingency, Scott, before we move on?
Sure.
So one of the other things that I want to address is, guys, we're here with a watered down version of real estate because of bad actors. And so while we're giving you this tool of hey, you can have this contingency you put in and make it contingent upon a buyer or seller, a buyer or a tenant seeing the property before they're obligated to spend money or even deliver earnest money. One thing I want to warn you about is that, as Scott said, brokers are a creative group. And my biggest fear is that people are going to use that contingency, and instead of just doing one contract at a time, they're going to put 14 under contract. And then they're going to go out on Saturday and look at 14 properties. And then they're going to terminate 13 of them. And the reality is that is going exactly against what the AG is trying to do. That is creating more contacts between people. First of all, the Real Estate Commission has actually disciplined people for that practice when we weren't in a pandemic. I'm sure it won't be any different now. It goes against contract law. It's a question of good faith. But it is going to create problems that you guys might find you lose your entire industry. And what I mean by that is that if you don't safeguard your industry and play by the rules and do the things you're supposed to do, you might see the Attorney General start ratcheting it down again and saying, okay, well, if they can't abide by this, then we'll just make real estate not essential. There have been states that have done that. New York, it was essential. They made it non-essential. Pennsylvania carved it out. Even in Colorado, there are counties that have made real estate non-essential, namely San Miguel County, Pickens County for a while, but I think they changed their interpretation. Eagle County for a while, and I think they would change their interpretation. But also Gunnison County is still non-essential. So you guys don't want to play these loopholes. It's not about trying to find different ways to do showings and calling them something else. Understand what the intent of this order is and really try and concentrate on the fact we're trying to eliminate contact between people. And that means one contract, one buyer.
Yeah, that's important for a lot of reasons. I mean, don't forget that the contract does say that, earnest money, once you enter into a contract, if the buyer is in default, then earnest money is due and payable to the seller, even if it hasn't been delivered. And so to take Damian's point about good faith a step further, if you're putting multiple properties under contract and not disclosing it or, doing that even at all, there's certainly good faith arguments. And so even if your buyer hadn't delivered alternative earnest money, if they terminate the contract and don't disclose that that particular one is one of multiple, even 2 or 3 contracts, there's some reasonable argument that bad faith would be independent buyer default in its own right, and the seller could pursue the buyer for the equivalent of the liquidated damages. So it's a risky gambit, in addition to the fact that it's not at all consistent with even the spirit or even the spirit of the shelter order or the stay-at-home order. So the last thing I'll say is that order, for those of you guys that don't know, it expires April 26th currently. I don't know if Summit County, Sarah, do you know if Summit has any independent, or I know that like Eagle does and others do. Do you guys have something different?
Yes.
So whatever, when the state one expires, if there are elements that remain in the county or municipal, whatever you guys are working under, that go beyond that, then those would continue on through whatever expiration date you had in your local community as well. And so I just saw before we got on, I think there's about 5 or 6 Midwestern states that are ending their current orders end of April. I know I saw yesterday some of the larger states are doing it May 15th. We've been actively working with the governor's office, with DORA, to the extent possible with the AG's office. Obviously all of us are hoping that we can phase back in and the order can be, substantially scaled back, if not eliminated, on the 26th. In the event that it's not, then we are already working to try and make sure that we have, a sort of a set amount of items that we can actually expand into, and hopefully some form of, showings with certain restrictions, and to get a little bit more, basically, because if this gets on for another 2 or 3 weeks, I know, you guys are, you're stressed and want to get back to business and everything else. And so those conversations in anticipation of the potential even for an extension are already occurring actively within our, lobbying contacts and everything else. And so do be aware that we're hoping to try and sort of get back to, it's going to be a long time before business as usual, but try and get back to some approximation or ability to at least bring new listings on the market. So one of the things that I've seen pop up here quite a bit, and maybe even in these questions, is photography and some other called tertiary businesses. And this is where I think there's a good example of brokers getting very creative in terms of, how they might obtain photography. But Damian, why don't you go ahead and chat a little bit about kind of the limitations on photography and the difficulty with a listing broker or seller trying to bring a new listing onto the market right now?
Well, I'll tell you guys, it's called a stay-at-home order, not a stay and drive around and go see your clients and take pictures order. It's stay at home, and as frustrating as it is, the whole entire point of the order is to get people to stay home so we can get past this epidemic faster and we can get back to get our economy rolling. And it's not just real estate, it's every other economy that's been put on hold at this point. The guidance from the real estate division, which incidentally, I know a lot of you have probably seen this. It's the one that they sent out on Thursday. It's the one Scott talked about in his opening, that the guidance that we got, that frankly, I think Carr did a great job. If you don't know, they were involved in really kind of pushing the governor a little bit on why are inspections not allowed. And that's why we got a better version of the guidance than we would have. But what it says is, it says, does not authorize real estate marketing services. And that means anything that happens before that contract. So that means you can't go over and take pictures. The buyer agent can't go over and take pictures. The photographer can't go over and take pictures. It means anything that is not a part of that contract doesn't count. I did get, to me, this has been the the clearest explanation as to what the Attorney General thinks is that, so I had a client email the Attorney General and they got a response back on Wednesday. And I'm just going to read this to you because I don't think they mince words here. And I'll be happy to send it to you, Sarah, if you want to send it out. But it says, thank you for your inquiry. While my office is unable to provide legal advice, we have been providing our position on current state pandemic orders for regulated professionals, including licensed brokers. My office's view is that the type of broker conduct depicted in your inquiry, which was entering residences to take photos, videos, even while the property is vacant or the residents are not in the premises, is prohibited by current state pandemic orders. Such services also would be prohibited by non-brokers, as these type of tertiary services related to the real estate industry, such as real estate photography, staging, videography, do not qualify as critical business, necessary travel, or necessary activity. Importantly, only real estate transactions are exempted and is a very limited exemption. I have attached recent guidance from the Division of Real Estate regarding this term and broker compliance with these orders. While this is probably not the answer you want to receive, it is essential to comply with these orders to ensure public health and safety. All people in Colorado must follow the letter of the spirit of these orders, and we implore all of you to try not to bend the rules and find loopholes. It is up to us to all keep people safe and build up our healthcare system so we can treat people who are sick and save lives. Your conscious business practices are greatly appreciated during these challenging times. So I think that pretty much says it all.
It doesn't matter. One of the big questions that we get, and I think you've answered it, is, well, what if the property is vacant, right? We have a lot of second homes up here. You're saying no, nothing.
The stay-at-home order. It says stay at home.
Damian, what if I were to wear a black turtleneck with gloves and booties? I would only be in the house for 4 or 5 minutes, and I would make sure I wiped everything down.
Oh, well, then it's okay.
Oh, okay, good. We know the answer is no.
Yeah.
So I've been on a number of hotline shifts this week, and it's like, when I say creative, it's amazing the volume of calls, all with the same question. And I don't know how to say it any more clearly. And I don't mean to make light of this, because I know you guys are kind of, a lot of you are probably going, hey, this is killing us. It's killing our business. We're, whatever. And I get that. We get that. Carr gets it. Damian gets it. Everybody, Sarah understands. Everybody understands that. And it's and as I said in the beginning, we, Carr, and I don't think anybody here on this panel believes, that necessarily that level of restriction is appropriate. But the reality of it is, our interpretation, doesn't matter what a real estate transaction is. The Attorney General is chartered with enforcing these executive orders, and at this point in time, it's theirs. And so, again, hopefully this is a relatively narrow window. Hopefully that 9 days from now, this can expire and we can get some additional expansion in this. But in the meantime, I would really encourage you guys to be mindful of this. the thing that I've also been telling people is that I think it's a, so this isn't great legal advice, but I tell people a lot that, you only have trouble if you get caught. And there's some truth to that. But in this case, I think there's a pretty good likelihood of potentially getting caught or complained about, because we have right now, I believe, more looky-loos, nosy neighbors than at any point in history, because everybody is sheltered at home. They're bored. They're sitting looking out their front window or sitting on their porch if the weather's good or doing whatever. And they're nosy. And so when you have a sign in the front yard or in at a complex, a property listed as a listing broker, and you've got either people coming in and out of the property during the course of the day, or you're going in and out of the property during the course of the day, that unsettles people, and it creates an opportunity for somebody to actually file a complaint. And as Damian alluded to, I do know that the division has opened up a couple of investigations just this week related to complaints. I know if they're not licensed law violations, then they are obligated to refer those other complaints to the Attorney General's office. And so, there's a practical reality to the fact that if you're doing this stuff, then you could get caught. And anyhow, I'll leave that there. And I don't mean to sound like a lecture, but Damian, did you have anything else to add?
I'm going to just add one more thing, because we had something come in on chat that apparently Virtuance thinks they're critical business. And look, I'm going to tell you, I represent real estate brokers. I don't interpret legal orders for photographers. I mean, that's not my job. But frankly, I don't know what business they're in if they're not in photography, staging, and videography, which is specifically excluded under this AG's letter. So just because Virtuance says it's okay, you guys need to be careful. If you're the ones hiring them, if you're the ones that are involved in or encouraging them to do it, or saying that it's okay for them to do it, you're probably crossing the line. And I know it's not what you want to hear, but that's the reality.
We have a member who's a photographer who said that their association of photographers attorney weighed in on this and said it was okay. Have you heard anything?
I think he needs to go revisit the guidance, and he needs to go revisit that AG email I just sent you, and then ask him.
Okay.
Yeah, I mean, what Damian read and from that email, and I know you guys were just listening to it, and so the AG says clearly that the tertiary services do not qualify as critical businesses. There's two possibilities. One is they're either designated in the order as a critical business, which we know they're not, or they fall under the real estate transaction. And as we've defined the real estate transaction as being contract to closing, then, and I mean, I suppose if a buyer for whatever reason was sending a photographer in post-contract to take pictures, I maybe you could make an argument that somehow that's part of the real estate transaction, but it would be unusual at best. And so anyhow, again, I know there's a lot of perceived ambiguity, but at least in the way this is being interpreted, I don't think there's a terrible amount of ambiguity. And again, I get it. At the worst thing you can do as a broker, though, is interpret this for your related business partners out there, because that's not our job. It's not your job. They ultimately have to make those determinations. So, all right, let's do I got a couple of questions that are kind of going here. So I have a client who is under contract for a new home in the county that is contingent on the sale of their current home, also here in the county. As this is time sensitive, are we able to take on the listing of their current property so we don't run the risk of them losing out on their new home under contract, using standard marketing tactics, ideally with social distancing in mind? I mean, I'll just say quickly, no. I mean, so can you take on the listing? Yes, you can take on the listing. Could that seller take photos in their own house of their listing, of their home? Yes, they're not violating any shelter orders. They're not leaving their home. They can do whatever they'd like within their house. So if they want to take listings, if they have technology available to Zoom or to take 3D tours, virtual tours, if they want to get on and do showings virtually, and here I'm talking just about the seller that's actually doing that virtually. So if they want to get on a laptop or Zoom or phone or FaceTime or whatever and walk around their house and show their house, that's all fine, because nobody's violating the order in that case. But if you're talking about you as a listing broker going and engaging because there's emergency or it's an urgent situation or any of those things, it just couldn't be more clear that there's no exceptions for that. And so anyhow, so if we're pushing for virtual showings to?
Real quick.
Oh, sorry, Damian.
No, that's fine. I did hear from, I was on a call with one of my clients this morning, and one of the things that their photographers are doing is they said, look, as a service to your client, since we can't take pictures now, we can take them when the order ends, hopefully on April 26th. But they said, before then, how about we advise them as to what app to use and what filters they can do and how to get it in high definition and what lighting they should do and how to stage the property and walk them through it virtually to help your sellers put their property in the best light they can when they're taking pictures. That's still something that your photographers could do, because they can do that remotely and they can do it from their home and not have to be at the property. So maybe it's a pivot. Maybe it's talking to these guys about, look, if you can't do this, can you at least talk to my clients about how we help them so that we can put these properties on the market and see if we can find a buyer to put it under contract.
Good point. Yeah. I mean, I think wise photographers that are looking to, develop a good stream of business would be maybe providing some advisement in this, in this interim period to hopefully address some of that. So if we're pushing virtual showing to narrow down a property for a buyer, if I have a seller, is it okay to send a photographer into a already vacant home to shoot photos, videos? Sounds like we are displacing a tenant. Yeah. I mean, again, I'm joking about if they're wearing a black turtleneck and, wear booties and everything else, there's just no exceptions to it. And I know, so I expressed this yesterday in a phone call with the director of the Department of Regulatory Agencies. They're really pushing, let's use alternative technologies, let's use virtual. And I said, guys, listen, that's all great. And I think people are willing to embrace some of that. And that works well for a seller or listing agent who actually has already had a virtual tour filmed or, recorded. But for the rest of everybody else, it's a no-go. And so it's that kind of thing that I'm talking about, that maybe in an expansion, if there is any extension to this order, that I told them they have to acknowledge is that, if we've clogged the front end of the pipeline, we may get through the deals that are already in the pipeline and going down, to closing. But if they've stopped it at, the ability for a broker or listing broker to, professionally market, photograph, virtual tour a property, then we're stuck. So I don't know. We can't say that any more clear, I don't think. Let's see here. What happens when realtors do not follow the order? What happens when they have a photographer go in, videographer, Matterport? Is there a consequence? Talked with a managing broker for a local company who says their attorneys have deemed photography essential. Well, get an opinion letter from them, or have the photographer get a legal opinion from their attorney, and go have at it. Go ahead, Dan.
About consequences. I mean, the reality. So the Attorney General has the right to enforce this against anybody, and the enforcement is up to $1,000 fine and up to a year in jail. And last Wednesday, they arrested 3 people, unrelated to real estate, but they arrested 3 people for violating the executive order. So they do enforce this. I'm not saying that some photographer will get jail time or that they'll even get a fine, but guys, this isn't just a thing. There really is consequences. There really are people that are getting punished for it. And frankly, brokers, you have additional exposure because you're regulated by the Division of Real Estate.
Yeah, so I'll just touch on that piece real quick. It's actually kind of interesting. When this kind of first came out, my assumption was the Division of Real Estate really didn't have jurisdiction here, because the Division of Real Estate, they're chartered or their franchise is essentially to enforce license law or commission rules. And this is an executive order. It's neither a license law or commission rule. I've had a lot of brokers over the last week or so kind of challenge me on that point to say, well, where does the division get off? They don't have the right to enforce this. And my first kind of thinking about it was like, well, I guess they really don't, but they certainly would be responsible for referring it to the AG. And then in talking to Marcia a little bit, both Damian and I, she pointed out 2 areas that they would potentially pursue an investigation. And it sounds like, based on knowing that they've opened at least 2 investigations this week, 2 areas specifically that this might fall. One would be under the commission rules related to incompetency or unworthy practice. In other words, if you're performing brokerage services and the health risks and the fact that it's not appropriate to be doing and that your clients shouldn't be doing this stuff, then it could be. it could be an incompetent or unworthy practice. And then what section is that, Damian? That's the competency is 7 point. There you go. I saw that yellow book behind you there. And then, but the second area that Marcia mentioned is uniform duties. In other words, you have every broker in a brokerage engagement has a uniform duty to not do things that are illegal. And this executive order has the effect of law. And so it could be also a violation of your uniform duties under the Brokerage Practice Act. And so that's how, if they were to pursue it, they could get to you on the regulatory side. The criminal side or the penalty side through the order, as Damian mentioned, is up to $1,000 and up to a year imprisonment. So it's I don't know. There's some teeth to it. Whether or not it gets enforced, I'm not exactly sure. But I guess that remains to be seen. Any thoughts, Damian?
No, I agree with you. I had heard from somebody, but I haven't been able to verify it yet, that they did actually end up finding somebody. So I imagine that at some point we're going to start seeing people punished for this. The problem with the Real Estate Commission is that they don't meet until June. So there's a good chance we could be through this before all of those complaints make their way through the Real Estate Commission and we see what the consequences are.
Yeah, that's true too.
Sarah, we have a pizza. Can you hear me?
Yes.
Okay. We have a Pizza and Politics next week with Marcia Waters on Tuesday from 12 to 1.
Great. So hopefully
that's a good plug. Well, I will say this, and I know Damian will agree with me and might even have some follow-up, but, she's a fantastic advocate for our industry. And, she has been, I don't know, how do I say this delicately? I think, she's been put in a bit of her office has been put in a bit of, in my opinion, at least, unfortunate position of being the sort of, it was their letterhead that was at the top of that correspondence you got last Thursday from the Division of Real Estate. And that has made them the target of some negative press and some negative comments on social media and other places. And I think it's important for people to understand that I certainly wouldn't speak for her, but I think she has some of the same concerns and understands our industry in a way that the AGs maybe don't fully understand, or the governor's office doesn't fully understand. And so I think for those of you that have frustration with where we are in the current interpretation of the order, please do be aware that, that they were essentially pasting the AG's writing on the division's letterhead. And so I can't really, speak highly enough in regard to how Marcia has contributed in a positive way, I think, to the situation that we're all in. So, Damian, you maybe want to add anything?
I don't really have much to add. I think you said it all. She's been
okay. So if you go under I'm sorry.
Yeah, she's been good to deal with. Absolutely.
Yeah. If you go under contract with a client who is out of state, who has not seen the property, can the local broker go into a property? Again, if they're wearing a black turtleneck and wear booties and hand gloves, and
they did say if it goes under contract.
Oh, I'm sorry. That's why you're a good lawyer and I'm not. So if you go under contract with a client who's out of state and who has not seen the property, can the local broker go into the property and do a video chat or take more pictures? I would say so.
I'd make that the contingency instead of it being a viewing. And you can still make it a viewing inspection and make it contingent upon, a virtual viewing, but it still has to be under contract.
I think it sounds much better if you make it a post-contract walkthrough.
Yeah, or a viewing inspection.
Post-contract walkthrough is probably clearer.
Oh, now's a good time to release the poll results.
Oh boy.
What do we got?
Here we go.
Oh yeah!
This is unbelievable. All right, I'm leaving the meeting. I'm out of here. I'm checking out. All right. Well, I should have advocated a little bit more for my position. My problem with inspection being in the nomenclature of Damian's contingency is inspection is defined in the contract otherwise. And, I wouldn't want to, because I even saw some question related to, well, could they do the post-contract inspection and then take a professional inspector with them. I think it's important to make sure, in connection with the contingency, to make sure that you're not foreclosing a buyer's opportunity to, at some point later in the transaction, actually perform an inspection. And so now that you guys understand the importance of the distinction, I would encourage you to post another poll here, Sarah.
Uh-huh.
All right, I'm done. I'm actually pissed at, there's a number of people on here, and if I could see your faces, I'd be yelling at you. If you go under contract with okay, we did that one. Yeah. So anyhow, I do think that if you've got a contract and you've got it as part of your contingency, and that you're going to go into, there we go. I got a 1 vote change. Make that noted. If you go into the property, I think you're acting within the order in that case. Can SAR modify their MLS rules about requiring pictures to be inserted in the MLS with any new listing? It would be nice if we could enter a new listing in the MLS, but not including pictures until they are allowed. I'll leave that to Sarah or somebody else.
Yeah, we can have the MLS look at that, but we'll see. No promises.
Okay. There's that, and then there's also a lot of questions about, MLSs that actually conduct the facilitation or the scheduling of their showings. And I think, in this current environment, one of the biggest frustrations is I'll kind of go off topic a little bit here. As we talk about this stuff, I think it's funny. It reflects a little bit of the political, maybe not political spectrum, but just the differences in how people perceive the relative risk of all of this. And we have members who are saying, bravo, you guys are doing a great job of advocating, and we support this, and it's important that we're all in this together and we all cooperate with this. And then we've got other members that are like, you're killing us and you're not doing what you should be doing as a trade association. And so what I think that reflects is there are people that are willing to completely ignore the executive order. In other words, many of them probably wouldn't even take the time to participate in an event like this. But then what happens is the people that are conscientious and trying to sort of play by the rules are frustrated because there are a few people not playing by the rules. And that's where I've had probably as much frustration as anything. I mean, everybody gets that their business is being inhibited right now, but they're really ticked about their business being inhibited when not every other realtor or every other licensee's business is being inhibited. And so, that's where I think, to the extent that MLSs or showing, companies or schedulers or whatever have you, are not cooperating in those, we'll call them bad actors that are ignoring the order by allowing the scheduling of showings, at least conveniently anyhow, I think they're contributing to maybe more of the solution. So.
Yeah, and there's several different MLSs that have done that so far. You told me about a couple, but I have a client that says that one of the associations is implementing fines and penalties that if people show, it's first one's a $500 fine, second one's they're going to take away MLS privileges. I mean, so to me, it's a good thing because we should all be on the same level playing field.
Yeah. Contract-wise, can one can inspect multiple times? Yes. There's no limitations. I mean, I think there's some reasonableness if you're trying to drag, people through during a due diligence period every day. A seller would have some ability to object that, buyers maybe not being reasonable. But no, there's not only one inspection. There certainly could be more. And if the question is like, oh, you can only have the one inspection, related to my nomenclature with regard to the post-closing walkthrough thing, I would not. I mean, in all seriousness, because I think that's maybe the gist of the question. I just would be clear about it. That's what I'm saying. I mean, absolutely, a buyer has a right to perform reasonable inspections related to the premises. But if you're going to do a post-closing or a whatever silly name Damian has for it, and call it an inspection, just be clear that there's actually going to be also another, professional, let's call it inspection, if that's the buyer's intent.
Yeah, you need contingencies.
Yeah. Regarding inspection, you have until the inspection objection deadline to have as many inspections as you want. Walkthrough is mentioned in the contract as well. Well, Dan, yes and yes. Final walkthrough is what's mentioned in the contract. And yes, inspections, as we just talked about, you can have as many as you'd like to have. So Damian's clause name is okay. Okay, are you paying this lady? Again, listen, this is all just kind of, I don't think either one of us really care about the other person's clause name. And I don't actually have, here's the other thing that is Damian's in a position where for his clients, his individual clients, he can write clauses, he can call them whatever he wants. I'm limited because, my client is car. And while that's great. I have just one client. I can't have, 28,000 realtor clients around the state. So I'm not even allowed to write clauses. So maybe we should just leave it there, that whatever I call my clause is it doesn't matter anyhow. You're really making Damian's Friday, people. Does the MLS
awesome. Awesome.
Does the MLS or SAR have the right to impose fines for showings? Is that legally strong position? Okay, so good question, Dana. And this has been, I've had, like I said, 2 or maybe 3 different MLSs or local associations that own the MLS individually and control showings or have a disciplinary schedule or fine schedule, contact me to say, hey, we're thinking about doing this. And I know that 2 of them have. And my only guidance for them was, listen, I can't be your attorney, so I'm not going to review your bylaws and your MLS rules, and I can't interpret that. But do be careful to make sure that whatever policies you put in place are consistent with what you're able to do in your bylaws. So I don't know if SAR does or if they don't. Ultimately, before they make a decision to do something like that, they need to consult with their own board attorney to make sure that it's clear they can do that.
Thank you.
Who's liable? The listing agent for allowing the showing or the buyer's agent for showing the property? Go ahead, Damian.
Well, here's the problem. So first of all, the buyer's the one that's violating the order and the buyer broker. So it's both of them are in violation. But who's going to get caught? I mean, you see the neighbors next door watching this parade of showings go into a house. He has no idea who the buyer broker is or who the buyer is or who's actually violating the order. All he knows is there's a sign on that house that says who the listing broker is. And so to me, the problem is that even though the listing broker might be at home and not doing showings, the listing broker is going to be the one that ends up with the complaint for, number 1, enabling the showings, and number 2, that's the name they see. So I think the risk is for both.
Yeah, I would agree. I mean, I maybe delineate that with this, and maybe that's what he said. I was trying to read another question. I don't listen to him much anyhow, but it is the buyer who's violating the executive order. So they would have theoretically the attorney general. They would be subjected to potentially $1,000 fine and a year imprisonment. But either or could be in violation of a complaint to the Division of Real Estate. In other words, the incompetent, unworthy practice, or uniform duty violation, or whatever have you. And so I don't think somebody who isn't actually specifically leaving their home could violate the executive order specifically. So I delineate there. So there's some of the Q&A. It looks like maybe some people were leaving questions there, and I'll just try and run through quickly a couple of those. Can agents preview a vacant property? We talked about that. No. Any legal addendums we need to be using? Where can they be found? Damian, go ahead and touch on the COVID addendum real quickly, maybe.
Yeah. So I'll tell you what happened is early in this pandemic, we had a lot of people that were creating their own clauses, borrowing stuff from other states, borrowing addendums from other states. And the issue is that Colorado didn't have anything. And I know Scott, you were getting inundated with questions about what do we do and what do we use. And so talked to the Division of Real Estate. Division of Real Estate said, hey, our meeting's 3 weeks off. And even if we could get it on the agenda for 3 weeks, there's nothing that says they'll approve it or we can move that quickly. And so Scott came up with a great idea. Years ago, he helped negotiate into the statutes a provision that said that the Bar Association could create forms for use by brokers. And so Scott on a Friday, sent over a request to the Bar Association and asked for an addendum. And the Bar Association, the Real Estate Section Council in particular, decided that, you know, it made sense. So the COVID-19 addendum comes from collaboration with CAR as well as the Colorado Bar Association, and they actually got done in 3 days. It was out on Tuesday that following week. I will tell you, when that COVID-19 addendum was created, it was created when there were no stay-at-home orders. There were no, we didn't know really what was going on. We had a clerk and recorder that had closed in Adams County. We had Jefferson that was threatening it. We had people that were supposed to be staying home. And we had no idea what the fallout of this whole thing was going to be. We had no idea what was coming next. So when they created that COVID-19 addendum, they put in 2 paragraphs. And the first paragraph is what I call, you know, a shutdown paragraph. And it's if the settlement service provider or a government entity shuts down or is unable to perform, then there's this delay period that goes into place. And you can read the form, but it essentially says, you know, you get a delay of so much once this happens. The second paragraph is what I call a quarantine paragraph. And the quarantine paragraph says that if one of the parties is mandatory quarantine, voluntary quarantine, or if there's a stay-at-home order, that you get this extension as well. Because we're now under a stay-at-home order, I'm not sure that the second box is necessarily appropriate right now. Now, it may be again later, maybe after April 26th when the stay-at-home order gets lifted or whenever it does get lifted. But the problem with box number 2 now is that if you check that box, then either party at any time during the course of the transaction can just send notice to the other side and they get an automatic extension. Now, that all being said, I still like paragraph 1. I know there's people that don't, but I'll tell you the most important thing about this addendum is that it really is a conversation starter between the buyer's side and the seller's side about the fact that we are in a world that changes every day. Last week, it changed 4 times. So, you know, it's really a tool to help you guys start having those conversations, even if it doesn't work for your particular issue that you have come up in the course of the transaction. By setting an expectation early with the buyer and seller, talking about the fact of things are going to come up, we're going to have to work through them, we have no idea what curveball we're going to be thrown tomorrow, I think it'll help you guys be able to navigate and negotiate your way through a transaction to get it to closing. And to me, that's probably the most important thing that form does.
Yeah, I would agree with all of that. And Damian's very gracious with his credit, but you know, I'd say 80 to 90% of the language in there is stuff that came out of his office or pen or what have you. And you know, he's a member of Real Estate Section Council on the bar and was instrumental in sort of facilitating their consideration and review of that. So I'm not gonna give him too much credit for things, but he's pretty helpful throughout our industry in ways both seen and unseen. I'll just say that. Let's see here. Virtuance, you talked about that. Who wins the grudge match? Our seller hired them so we can list their house ASAP. Oh no. Sorry, I'm just reading the comments, and some of them are relevant, some of them aren't. All right, well, I guess I got through those. All right, well, we're getting kind of close to the end of the hour. Damian, you want to go ahead and maybe give some comments and kind of wrap up?
You know, I will just say this, is that we need to remember what the intent of the order is, guys. And I think we get too focused on, oh, we can't do our jobs, and oh, this is being taken away, and oh, that's being taken away. But at the end of the day, our economy has been stalled. And we have 22 million people that are now unemployed. We have Boulder just announced they're laying off 800 people. I mean, our economy, we need to get it restarted. And the only way to get this restarted is for us to comply, to help limit contact, get us past this glut, and hopefully get us back to a place where everybody can start performing in the economy. And that's going to take the cooperation from all the brokers and doing your part to make sure that we stay safe. So this is a real thing. There are a lot of people that are dying and that have been harmed by it. And I just hope that you guys all stay safe.
Yeah, agreed with that. Well, I'm sorry, I missed, there are 2 more questions popped up, and one of them I actually think is important to answer. I think they both could be, but I have a Zoom showing this afternoon with sellers showing their home to buyers around the property via Zoom. I am the listing agent, the buyer's agent will be on the Zoom call. Is there anything we need to be concerned about with all the parties together on the Zoom call? I think that's a good question. What I would probably do is instruct your seller to sort of allow you as the listing broker to, be the primary mouthpiece as opposed to having them say things. I mean, it depends on your seller, obviously. But what you wouldn't want is, to have them, I don't know, they're not professional real estate marketing people. And so you just might be better off driving that. I think that's a good way to handle it. I have heard of people allowing the buyers and sellers just to do direct FaceTime with each other and the brokers aren't involved. And that is always has a potential for problems. And so I think your solution using a platform like this, where multiple parties can be involved and see, and but maybe just as the listing broker to really instruct your seller to let you sort of take charge of at least the audio version of the virtual tour. I think we can all just agree on putting the verbiage Damian Cox viewing provision in the additional provisions. All realtors statewide will know what that means. They will. And when it gets them in trouble, they'll know who to blame.
Sweet.
And read the preamble to the Realtor Code of Ethics. Yeah, well, that always helps too. Okay, so here's what I'm going to say just to close up. I think that this is a cruddy time for everybody, not just us, everybody. But I know how what you guys do out there is you constantly live with uncertainty because you're not on salaries. You need deal flow. You need transaction flow in order to be making money. And I know how much your normal careers have uncertainty, and then when you lop on a bunch of additional sort of pandemic uncertainty on top of that, it's really, really hard. I would just encourage you guys to be mindful of this. For those of you that heard me at my 10 Things class this last year in 2019, one of the things that I was talking a lot about was the NAR lawsuit and the challenges to our industry from the technology companies to the disruptive business models, to the iBuyers, to the antitrust allegations, all of the challenges to what you guys do and to your value proposition, and that you're overpaid, your commissions are too high, and all of this other stuff. Right now is where you will be defining your value proposition for years to come. Your ability to keep transactions together, to keep sellers and buyers, cooler heads on, to come up with creative solutions, to have ideas, to be thinking out of the box. All of those things is where you will have a response when people challenge you going forward for years to come on your value proposition. And I think it's something that, if there's any silver lining, anything you can embrace out of that, and anything you can do in this time, when you have extra time, is in your business plan, is to be thinking about that value proposition and how you're going to use and be able to articulate everything that you've done in this period and everything else that you bring to a normal transaction in a normal time. Be thinking about that stuff. And the last thing I'll say is this: for those of you that make it through this, and I'm sure all of you will, because hopefully this is not a long-term endeavor. Those of you that make it through it, every one of you will be better brokers than you were when you went into it. And that's another piece that I think you need to be mindful of and to appreciate, if there's anything to take from this, just really cruddy place that we're all at right now. Those are a couple of things that I would encourage you guys to hold on to. And keep your chins up, stay healthy, and you've got a great local leader there with Sarah. If anybody ever is feeling down in the dumps, just have Sarah give you a smile. As I've told her 1,000 times, her smile is electric. See, and now she blushes too.
Thank you. Hey, we appreciate your time today, guys. I cannot thank you enough for this insight, and I think it was very, very helpful. And I don't think you could have been any more clear as to the current situation. So if any of your fellow brokers, guys, are asking any of these questions, you need to send them this recording, send them the AG letter, which we will send out to you shortly. And hopefully this will all change in a few days when we get released from the executive order. We'll start to be able to do things. Have you seen, you alluded to this earlier, but have you seen or heard anything that realtors might be allowed to do as we open up?
I have not. Everything's going to be staged, I think, is what everybody's saying. And this is not like any inside knowledge. This is just from, sort of paying attention to the news and everything else. What I did mention earlier, and the CAR is actively working now. We are trying to develop a written set of guidelines that we're going to be presenting early next week to DORA to sort of set out some parameters for for what we believe would be good first steps for our industry to kind of get things going in a bit of a staged area. And what we're doing is reaching out to our to other states through our through NAR's network, essentially, to find out what other states are doing and how their limitations they're putting on showings, and they have to all be private and scheduled, and just some best practices that we can hopefully present and have incorporated. So stay tuned on that. We'll see what happens.
All right, great. Well, thanks again for your time. And then again, I'll just reiterate, Pizza and Politics, Tuesday, April 28th from 12 to 1 with Marsha Waters. Thanks, everyone. Have a great afternoon.
Thanks, guys.
Yeah.
Thanks, Damian.